I call this full committee of Judiciary Non Civil to order. I appreciate everyone coming out. I'm going to ask that Representative Moptahan would give a word of blessing.
Let's bow. Lord, we thank you for this day, Lord. Just thankful that we can meet out here, Lord, and do the work of the people of the great state of Georgia. Lord, we're thankful, Lord, that you've allowed us that opportunity. Lord, if you just be with us, Lord, give us wisdom and guidance as we make these decisions on behalf of the people we represent back home. In Jesus' name we pray. Amen.
Thank you, Representative Moptahan. We've got several measures to hear. We've added a few measures as well. So I'm going to get started. I'm just going to let everybody know we've many of these bills we have vetted through the subcommittee process, and we'll continue to do that here in full committee. But a lot of work has gone on with all of these bills. So just if you had your question answered, I would ask that we don't regurgitate the same questions over and over, just in the essence of time. I know that we had a marathon yesterday, and we're likely to have a pretty long meeting today. So keep that in mind. I want to get this right. But if someone else has made the point you're making, please refrain from doing the same over and over. I appreciate that. We're going to hear House Bill 255 first. Representative Holcomb. The LC that I have is LC 280282S. Is that the correct?
That's correct, Mr. Chairman.
All right. I appreciate you coming. And if you would present this bill, tell us what it does and why we need it. And I'll turn the floor over to you.
Okay. Thank you, Mr. Chairman, members of the committee. It's my pleasure to bring this bill to you. This is the work of about 2 years from the state has an expert committee that convenes regularly to examine our state's policies with respect to its response to sexual assault. So these are all recommendations that came out of that state expert committee. I am a member of that committee and have been for about 5 years or so. And so this bill was longer at the beginning. It's a little bit shorter now. And part of that is because some of the ideas and concepts were put into other bills, so we didn't need to duplicate that. So with that, let me just walk you through the changes that are being proposed. In Section 2, current law now requires every judicial circuit to have a sexual assault protocol. Not all of the circuits are complying, and a number of them have not been complying for some time. So the idea to prompt compliance was to have a requirement for annual certification. So that way we would know if everybody has the protocol that they are required by law to have, and that just sets forth those criteria. Section 3 changes the language that we have regarding kits that are unreported. There are two types of kits when it comes to sexual assault. One is when the victim immediately wants to report the case to law enforcement. The other is when the victim does not immediately want to report the kit to law enforcement. Those can be very difficult decisions. For example, incest or some other issues where there are valid and legitimate reasons for waiting. So the advocates wanted to change the law to make it better reflect what is actually happening. And the language which we're recommending going away from states, if the victim does not cooperate with law enforcement, that hints at the victim not doing something that the victim should be doing. So to make it more neutral, the language be changed, if approved by the committee and beyond, to if the victim chooses not to report the alleged sexual assault to law enforcement at the time of evidence collection. And then it sets forth the requirement for the agency to hold it, which we're not changing that. We're only changing the text that is underlined. Section 4 of the bill is really the meat of the bill. And this is the biggest shift, but I think that it's a really important one and one that I support wholeheartedly. And what this would do is it would build upon the state's very strong efforts to address the timeliness of the processing of sexual assault kits and then bringing cases to prosecution for these crimes. We've spent a lot of money, resources, and time to end our state's backlog, with the Georgia Bureau of Investigation doing some really incredible work on the testing. And what this would do is it would set forth a statewide website that victims could then track the status of their kit from the time that the evidence is taken all the way through prosecution. My understanding is 27 other states have similar systems, so it's important for Georgia to have it as well. The Criminal Justice Coordinating Council has been working this for some time, but putting it into code will ensure that it's up and running. And there's a couple parts of here that I'll point out to you. One is, if this is approved, then the plan by CJCC will have to be provided to the appropriate committees of the legislature and the governor no later than January 1st of 2022. That's on line 68 and 69. And then the system needs to, or then what they will do is they will roll it out on a phased basis, because we want to make sure that this is successful. So the language is all there, describing that process, with, again, the end goal being to have an interface, a web interface for victims to be able to track the status of the evidence in their cases. It also has reporting provisions, which I think are important for the General Assembly to see how long testing is taken and the overall volume of kits. And my ultimate goal is that we can reduce the incidence of violence to begin with. And I think that that data may be helpful in that cause. And then the last substantive section is section 5. And what this would do is set up an information sharing process with the Federal Bureau of Investigation with respect to its Violent Criminal Apprehension Program, also known as the VICAP program. These are the truly most heinous, most serious crimes out there. They are your serial murderers, your serial rapists, and this would, in an attempt to try to solve more of those crimes, which are very difficult to solve, have an information sharing component between our state law enforcement and the FBI. So that's a summary of the material provisions. I'm happy to answer any questions or to go into greater length, but as mentioned, this has been widely coordinated, pretty heavily vetted as well, and has the support of the State Expert Committee, which consists of all the actors which interface with this issue.
Thank you, Representative Holcomb. I appreciate you bringing this bill. I'm gonna, before I ask from discussion of the committee, I'm gonna ask the subcommittee chair to give a report on the bill, if he is ready. Chairman Reeves.
Yes, and sorry, Mr. Chairman, Representative Mclaren and I are trying to work out some language on one of the other bills that we're working on in here, but Representative Holcomb's bill is a continuation of an effort that he has been a part of since I got here, and has been steadfast in, and I respect the work that he's done, and I absolutely trust what he brings us, and I think that this is a great step in the continuing effort to get the evolution of being able to solve sexual assault crimes, making that as efficient and as close to perfect as we can possibly get it. So thank you.
Thank you, Chairman Reeves. I have, I'm going to open it up for discussion for the committee. I have one question from Representative Boady.
No question at all, Mr. Chair. Just a comment. I want to say to the gentleman, great job, great work. You have, I think every session since I've been here, have worked to improve your original rate kit bill. And I really appreciate your hard work and dedication. And you have been able, by your work, to solve a lot of John Doe and Jane Doe crimes in this state. So thank you so much. And at the appropriate time, I would like to make a motion, Mr. Chair.
Thank you, Representative Boady. I have six. Representative Byrd.
Thank you very much for this bill. What happens, I am the chair of the North Georgia Angel House, which is a girls group home 12 to 21 years old. And if anything were to happen to those girls, which has happened, it is my understanding through the executive director, they have failed to take the child's underclothing to see what DNA may happen. So could you tell me what is the process for younger girls who happen to be living in a foster care system?
Representative Byrd, will you move to 5? Because I don't believe your mic is working.
I don't want to sit that close.
You move the mic around, maybe it might start picking up.
I can try to re-ask or restate the question if that would help into the. microphone.
Sure, that'd be helpful. I don't know that actually, go ahead, Representative.
Okay. The question was, with respect to young girls that are sexually assaulted, what is the process to make sure that we're capturing that evidence? Is that correct?
That is correct.
There's two basic methods. One is to go to a sexual assault or rape crisis center, and we have a number of those across the state. The state helps to fund those, or to go to a hospital. One of the provisions that we were working on and are going to continue to work on is there are nurses that are known as sexual assault nurse examiners. They have special training in terms of how to respond to sexual assault and know how to take the evidence. What I'm going to continue to work on in this space is to make sure that the state has appropriate assets of sexual assault nurse examiners across the state, so that everybody that needs access to one has access to one. Because it's very important from an evidence collection standpoint that be done correctly and appropriately. And that impacts the ultimate prosecutions and with the chain of prosecution and everything else. But the best, certainly, I hope this never happens again to anyone in this state. But if it does, my recommendation would be a rape crisis center in your community, or to a hospital that has the resources to be able to appropriately take the examination.
Thank you.
You're welcome.
Thank you, Representative Holcomb. Now we'll hear from the audience, and I don't have anyone signed up. I have one person signed up here. Nope, I have no one signed up to speak to 255. Is there any more discussion out of the committee? Hearing no more discussion, the time is now appropriate for a motion.
Chair, I make a motion do pass on HB 255.
We have a motion to pass.
Second.
Second. I'm going to call the question of
Hey, yep.
5 LC 280282S. All those in favor of, excuse me, I'm sorry. Is there any amendments? No amendments? Hearing none, I'm going to call the question for House Bill 255, LC 280282S. All those in favor signify by saying aye.
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 Online?
Aye. Aye.
Darshan, are you online? Excuse me, Representative Kendrick.
Yes, I said aye. Can you hear me?
We can't hear you. All those opposed, like sign. The measure passes on the rules. I appreciate your hard work on this, Representative Holcomb. Well, grab a rule sheet and let's get it filled out because we know time is dwindling.
Yes, sir, Mr. Chairman. Thank you, members of the committee.
Representative Gunner. The next measure we're going to consider is House Bill 556. Representative Gunner.
Chairman.
Hold one. We got a little.
Are we even still around
We
for?
can hear you now, Representative Kinder.
Okay.
Boady, you got your button. All right, Representative Gunner, thank you. It looks as though you have another Judiciary Non Civil bill in committee.
Yes, sir.
I share in Representative Williams' wonder as to how did the judges get along without you?
Quite well, I'll say.
Well, I have a House Bill 556 with LC 413068S for consideration. If you would mind giving an explanation of what your bill does and the changes that were made,
All right.
and I'll turn it over to you.
Thank you, Mr. Chairman. House Bill 556 is the bill for trying cases by accusation. We have a huge backlog of cases in the system right now, and this would be one way to get a lot of cases into the system so that they can be tried. This does not allow for the 7 deadlies to be done by accusation. And any case where you would bring it by accusation that normally would go to the grand jury, it has some conditions on that. If it's been bound over pursuant to a commitment hearing, there's been a finding of probable cause. And so that case would qualify to be accused expressly or by operation of law. And I'm looking at lines 89 through probably 95 or so. Where if you've waived the commitment hearing, you've waived the finding of probable cause and been released on bond commitment, pending a commitment hearing, you're still retaining the right to it, but you're out of jail and been confined in jail for at least 45 days, unless such time has been waived. The 45 days is normally, if they're in there for 90 days, it's a requirement that they be indicted or let out on bond. And so the 45 days now puts this to the DAs to be able to accuse it and move the case even quicker. It has a sunset on it of June 30th, 2022. And the substitute is what's been brought as the change here. We had 2 bills that we were looking at, House Bill 555 and House Bill 556. And these 2 bills arose out of an agreement between the prosecutors and the defense counsel in order to break the logjam of cases that are in the system right now. So this was a way of getting cases moving. 555 was a case for, or was a bill for the criminal defense or defendant to ask for a bench trial rather than a jury trial over the objection of the prosecutor. What I guess the problem that the prosecutors had with that bill was it didn't include the 7 deadlies. And that's under Code Section 1710 6.1. That's been added into this, and the sunset was originally June 30th, 2023. It's been shortened to 2022 by 1 year.
Where did we add that in? Would you point me to it?
The sunset
No, the addition of the 7 deadlies.
on the first page, lines 14 and 15.
Okay. All right. And then we changed what we changed the sunset date from to?
June 30th, 2023 to June 30th, 2022.
Okay.
And that's on line 32.
All right. Do you have anything else to say, Representative Gunner?
No, sir, that's it.
Well, I'm going to open it up for discussion from the committee. Anybody have any discussion? We have a few people signed up outside the committee. I'm going to open this up to the audience. I'm going to ask that Cheryl Carus, if you're out in the hall, come in and testify, please. Okay. All right. Well, she come on.
Hi there.
Thank you, Ms. Carus. Would you introduce yourself and tell us who you're with and speak to the bill?
Thank you, Mr. Chairman. My name is Cheryl Carus. I'm with the Judicial Council Administrative Office of the Courts. Both of these bills that are now combined into House Bill 556 are ideas that came out of Chief Justice Melton's COVID-19 task force. Both of them are ideas that address the backlog that we're going to be experiencing once we are able to restart jury trials. And we appreciate you revisiting this issue. We feel this is a balanced approach, and we're good with the changes and the substitute.
All right.
And I know Judge Gosselin was going to be on Zoom, so I just wanted to make sure that you.
Well, since you're here, I'll go ahead
Sure.
and ask if they're on. Judge Gosselin, would you mind speaking? We're going to let you go ahead and testify.
Okay, I'm here. I appreciate the opportunity, Chairman and members of the committee. Just to back up what Cheryl said, I was a member, I still am a member of the COVID task force. So the Judicial Council and the task force hope that you will pass this bill now that has been combined and vetted again through the DAs. I think Representative Gunner's done a good job of doing all that for us, and we appreciate your thoughts about it. I did want to be here so that there was a judicial presence in case you had questions more than anything else. So I'm a Superior Court judge and have been one for over 20 years. So in case you have any questions.
Well, thank you, Judge. Thank you, Judge Gosselin. I'm going to ask if there's any questions from the committee for either one of the folks here. Please go ahead and ask now. Seeing no questions or discussion. Oh,
Keep pressing.
Representative Byrd.
That's it. Okay. I just want to be sure that nice to see you again. I know we talked about line 14 just now about serious violent crimes, the 7 deadly sins. Does this also include whatever else is defined as a very serious crime?
It's serious violent felonies, and that's more than the 7 deadlies. And it excludes those in line 16 on the next page and 17. So it excludes those from being able to be in a bench trial.
Thank you.
Thank you, Representative Byrd. That's everybody we have had to speak. Is there any more discussion? Any more discussion by the committee? Hearing no more discussion, now's the time to entertain a motion. We have a motion. Do we have a second? We have a second. Any discussion or amendments? Hearing none, I'm going to call the question to House Bill 556 LC 413068S. All those in favor of this measure passing, please signify by saying aye.
Aye.
Any opposed? All right, is the opinion of the chair, the measure passes. Now on to rules. I appreciate
Thank you, Mr.
Representative Gunner and all those that came to testify. Yes, sir. The next measure we're going to call is House Bill 327. Representative Montahan. You want to present from there, or would you? Okay. It's fine by me. Do you have a mic? Okay. Representative Montahan, tell me what your bill does and why we need it.
Okay. Thank you, Mr. Chairman. Mr. Chairman, today I have House Bill 327. This is LC 280288S. Chairman, as you know, in the past 2 years, we brought this measure forward. Last year, the underlying bill passed out of the House and got killed due to COVID-19 session ordeal. While it's an important measure, we wanted to be sure to bring it back this year. We did bring it back this year with some changes to try to capture some of the illegal activities that are happening on online marketplaces, namely Amazon and eBay and others. And while we are working on that section, We have actually removed that out of the bill. So let me repeat and be very clear. I know many members are getting emails from their constituents and others about what is in this bill as we move forward. It does not in no way include any of those craft handmade dealers. So the entire Section 3 has been removed from the bill. Make that clear. What this bill, I make it clear. That being said, what the bill does is it does a couple different things. It tries to capture folks that are reselling these gift cards. And so if I may, by operation, explain to you what's happening. I steal a tool from a local hardware store. I take it back. I get a gift card. I take it to a pawn shop. I get a portion of the value back in cash. Section 2 of this bill aims to capture that by actually having these folks either buy a pawn shop or another third-party reseller, or what we call a corporate let me go to that third-party card dealer. That is the actual term we're using now. So we're saying that these folks have to take down and retain some information so that we know who is doing these activities. And so that if the police or law enforcement agency needs to track these types of crimes, that the evidence is there for them to track. Moving forward, and I'm not going to belabor this. We've gone to this a million times. Section 3, again, of the previous bill's out. We're not capturing those folks. And the last section creates a new offense of organized retail theft. Well, that, Mr. Chairman, that's the bill.
Thank you, Representative Montana. Thank you, Representative Montana. I'm going to ask if there's any discussion from the committee. Representative Mclaren.
Thanks, Mr. Chair. Can you hear me? Just want to shout into the wind for the final time that I don't think we should create a 3 to 20 felony for corporations that could change their receipt policy. It's using the criminal law to subsidize big corporate customer goodwill. If you want people not to steal out of your house, lock the back door. That's all I got. Thank you.
Thank you, Representative McLaurin. Any more discussion by the committee before I open up to the audience? Hearing none, we've got one sign up. Mr. Busey, could you introduce yourself? Tell us tell us what you'd like to tell us about the bill.
Absolutely. Thank you, Mr. Chairman, members of the committee. Good to be before you again. I would first like to thank every member of the Reeves subcommittee, Chairman Reeves, Chairman Burchett, Representative Monahan, for your time and your patience on this issue. We've had a lot of great discussion, and we appreciate that and look forward to continuing those discussions on the part that's removed. What this bill does is essentially two things, I think, for the members of the committee that weren't with us last year. It's important to know that this bill is substantively identical to House Bill 488 as it was passed out of this committee last year. What we're after is organized retail crime and I don't have a sub, so I can't call you to line numbers. But in the section dealing with gift cards where the definitions have been changed, we're just making sure that everyone in the chain of possession that needs to be in the chain of possession of gift cards are, and those in the secondary market that aren't. Thank you, Representative Byrd. Much better. And that's really what that does. And I think we've belabored this to death. So unless anyone has any specific questions, this is just fighting organized retail crime, creating an appropriate penalty for organized retail crime that targets those that are the shot callers, that are the bosses in this incredibly large and complex and far-reaching criminal enterprise. It does not go after the most vulnerable of our population that are on the street level that are being directed to do this. This goes after the bosses of those that are making all the money. Atlanta's number 7 in the country in organized retail crime. 97% of all retailers in the state of Georgia will be touched by organized retail crime. So this is Wall Street and Main Street. And if anyone has any questions about retail crime or anything in the bill, I'd be happy to yield.
Thank you, Mr. Busey. Anyone in the committee have any questions for Mr. Busey or any discussion regarding this bill? Hearing no discussion, I'm going to ask that this is the appropriate time for a motion. We have a motion to pass. Do we have a second? We have a second. We have a motion to pass and a second. Do we have any amendments? Any discussion? Without any amendments or discussion, I'm going to call the question for House Bill 327, LC 280288S. All those in favor of the measure passing, please signify by saying aye.
Aye.
All those opposed? Is the opinion of the chair the measure passes? Congratulations, Representative Moptahan. Will you please get a rule sheet and we'll get you signed up. I appreciate you working on that bill for us.
Well, thank you, Mr. Chairman, and thank you to the members of the committee for all your help and input over the last 2 years. It's been a wonderful ride.
Thank you, Mr. Busey. Representative Gullett. Sir. How about coming up there, Representative Gullett? We're gonna hear now House Bill 411, House Bill 411, LC 413072S. This is a bill that has been beat to death. We've changed. We've had a full discussion about this bill over and over again. We've had great bipartisan work on this bill. I want to just openly tell Representative Gullett, thank you for your hard work on this bill. I know I can see it on your face that it has been a tough tough measure so far.
Well, thank you. Put the mask back on.
You're not quite across the finish line yet, but
my good friend can say that anytime he wants to.
I'm not disparaging the gentleman from the 19th, but I know it has been rough on you, and I appreciate your hard work on this. And we're not quite there yet, but I'd appreciate it if you'd run through this measure here and specifically the changes we've made since subcommittee.
Sure.
And let everybody on the committee know what we're doing here. And I'm going to turn the floor over to you. Thank you.
Thank you, Mr. Chairman. So we're working from LC 413072S. It's a substitute from yesterday that was passed out of a subcommittee, and then we did a sub for this committee today. So I think it was like an amended version yesterday, sub today, including those changes and additional changes. So initially, this creates a prosecuting attorney oversight commission that would oversee elected district attorneys and elected solicitor generals in the state. It's not really, but it's kind of the JQC for prosecutors from a easy descriptive point of it. So it actually creates we have 2 panels that make up the commission. The commission is total 8 members, but there's an investigative panel of 5 members. And we also have a hearing panel of 3 members. So as we start going through, you start seeing line 21 starts talking about the 8-member panel and what the investigative panel is responsible for. And then the hearing panel starts at 33 of what they are for. So we defined an attorney, and I know my good friend Representative Mclaren is not an attorney according to this definition, but it's an attorney who means a lawyer who's been in active status of the State Bar of Georgia for 10 years and is a registered voter in the state. Citizen is an individual who's neither an attorney nor a judge and who is a registered voter in the state. And a judge means an elected or appointed public official who presides over a court of record. So what we start talking about, PAC gets to help or may recommend respective appointing authorities names for the appointing. So the 5-member investigative panel, which is line 52, the governor would appoint an attorney with prosecutorial experience And then the lieutenant governor would appoint an attorney with prosecutorial experience. And then the speaker would appoint 2 practicing attorneys. Remember, attorney is someone with 10 years experience. And then the Senate Committee on Assignments would appoint a practicing attorney with experience as a prosecutor, but not currently a prosecutor. And then the members of that panel, this is the investigative panel, they would elect their own chairperson and vice chair. And then line 75, we start talking about the commission hearing panel. It's appointees. That would be 3 members. One's a citizen member appointed by the governor. And then there's a district attorney elected by the full Senate. That's line 78. 82 is a former judge of the Superior Court, Court of Appeals, or former justice with 10 years experience as a judge or justice elected by the full House. And what we changed in that from yesterday was just the appointments and the prosecutorial experience there. So we kept some prosecutorial experience. We had removed some. Before it was the governor did a DA or appointed a DA. The lieutenant governor appointed a solicitor. We didn't change the appointment for the speaker, but we did, and we removed the 5 years experience as a prosecutor from the Senate Committee on Assignments. That's related to the investigative panel. We did not touch in any way the hearing panel's appointees and their qualifications. We did touch line 87. All members' initial term shall begin April 1st, 2022. We changed that language a little bit just to say it was just a little bit, I think, odd the way we had worded it, because the initial term was 1 year, didn't count towards it. So we made a change there. We talk about the quorum. So basically, from an investigative panel, there's got to be a quorum of 3 members, and then also from the investigative panel, in order to turn it over to the hearing, it's got to be a majority vote there. And then we began with line 133. The commission, with the assistance of prosecuting attorneys council of the state of Georgia, shall promulgate standards of conduct and rules. I think before we just said rules for the commission's governance, and will comport the due process and enforce the provisions of subsections H and I. And when we get to H and I is
what line are you on?
I'm sorry,
give us the lines the way
136.
you're going through this?
136.
136. Okay.
Yep. So H and I. So
and the significance of the language and promulgate standards and rules is because rules have been interpreted to mean the rules of governance of the committee, and the standards are the standards by which we're going to adjudicate these prosecutors. Is that correct?
That's correct. Yes.
Thank you.
So we every time we said rules, we also added standards there, except for the initial one, we said standards of conduct. So H, we did change. That's line 142. Yesterday's version, we had 8 total. This version, we have 7 total. What we removed was it was number 4 from yesterday. We removed habitual intemperance as one of the items. And on number 6, line 151, we included, I think we had forgot to include the assistant solicitor general. So we had said assistant district attorney. So on line 151, we added or assistant or assistant solicitor general there. Section I used to be what J was, but we added a section I. So section I is completely new. And I'm sure we'll have some discussion on that, but this is basically is really the restriction of this is they can prosecute, but they can hold the district attorneys accountable and solicitors accountable, and this is really where we limit what they can hold them accountable for. Is that right? Lauren, is that the best way to explain that, if you don't mind?
Representative McLaren.
Thanks, Mr. Chair, and thanks, Representative, for great work on the bill. The bipartisan spirit has never been pulsating so strongly in this committee in some respects. I feel like we all agree that what we don't want is for the commission to be used to second guess individual charging decisions that are made within the discretion of a duly elected district attorney or solicitor general. So the purpose of the second portion of subsection I is to put a limit on complaints that says that a complaint ordinarily cannot be used to second guess a charging decision, a plea deal, putting somebody on a trial calendar, et cetera, unless the complaint can show a number of or one of several factors, right? So essentially, the list from 168 to 173, and we've discussed adding yet another condition there today to make sure that prosecutors who have a stated policy of categorically refusing to enforce certain laws are not able to do that, right? And that's something that Representative Reeves and I agree about. So I think the purpose of this I subsection is just to clarify that H cannot be used, subsection H cannot be used to harass prosecutors and DAs and solicitors. But instead there's a set of circumstances in which it's appropriate to second guess or to call into question the way that their discretion is exercised.
So in layman's terms, we want to catch the bad actors, and we don't want it to be, going after unwarranted actions and leaving some discretion with the discretion with the prosecutors.
Right. And then on number one, we didn't talk about that, but we did it. That was basically when you make a complaint, you do a sworn affidavit detailing the complaint.
Yeah, that's a big point. You need
right.
to kind of hit that.
And so then they attach that affidavit to the complaint to support it. So I think that will help district attorneys and solicitors feel more comfortable about that. Going through the rest of the changes, really there are, we did change line 224. The commission shall commence by April 1st, 2022. And the rules and regs promulgated by such commission shall be established no later than April 1st, 2023. And what we added was there's no complaint shall be filed before July 1st, 2023. So that gives the Supreme Court time to bless the rules as we go through.
Yeah, that's an important note here. Is for everybody to know the ultimate deciding on these standards is going to be made by the Supreme Court. They have to, as Representative Gola said, bless off on these rules. So we have for any of those who may be concerned about this commission, we have the Supreme Court oversight here. So we have some very measured hands that are going to be, have their finger on the pulse, so to speak. Go ahead, Representative.
Yeah, and I think the last point is really O. Basically, we're just calling out the saying that the state bar, as well as the Supreme Court, they still regulate the practice of law in the state, and I think we're calling that out there and recognizing that. And I think that's an important aspect of the bill as well.
Yeah, and I'm going to touch on that a little. So this commission is not intended to step on the bar's toes or the Supreme Court's toes, but this commission is being created to capture actions that aren't caught by the bar. There are some actions that you can get a bar complaint and probably you can get disciplined by the bar. But they don't have the authority to remove you from office. And this commission will have that authority. Now the bar can disbar you, which would ultimately remove you because you can't be a prosecutor without being a practicing attorney. But if there was a scenario where a DA had some misconduct that the bar would capture, that would also warrant a removal, then they'd be disciplined by the bar and then this commission as well. We've got I'm going to open it up to the committee for any discussion on the bill if the presenter's finished.
I am.
Okay, thank you. I got a question online. Representative Kendrick, can you unmute yourself?
Yes, can you hear me?
Yes, we can.
Okay, thank you, Mr. Chair. And to the author, you alluded to that it was similar to the JQC. not too, I'm a lawyer, but I'm not too familiar with how the JQC is actually funded. I'm assuming there's some portion of state funds that have to be allocated to sustain that. Is that the same way with this commission?
Yeah, there is. There's a fiscal note for this. It's $980,000 annually, and I think there's a one-time fee of $225,000 for furniture for the office staff there. But it's appropriated.
Thank you.
Sure.
Thank you, Representative Kendrick. Representative McLaurin.
Thanks, Mr. Chair. A couple things we had discussed briefly today during the mayhem, trying to get edits in about ensuring that it was clear that the commission could bring a complaint on its own motion. And we had some language that we worked with PAC on to try to get into this sub. It looks like it might not have made it in because we were trying to get it at the end of subsection I-1, which would be on line 162. And the proposal, and if the committee is willing to put it in by amendment, would basically be to say nothing in this code section shall be construed to limit the ability of the commission to bring a complaint pursuant to this code section on its own motion.
I think that's a friendly amendment, and I think that at the appropriate time, I'd ask that you make that amendment because we do want the commission to have the ability to take action without without it being necessary for a complaint to be brought. So
And I agree. I turned that in. It just didn't get made for whatever reason, but that was
Are
a
you,
friendly amendment.
Sure. And my only priority, and that I think PAC sufficiently was able to get the wording right, is that we were clear that the complaint that the commission brings on its own is still subject to all the limitations that we've put in, which I think if you put it in I, and you say pursuant to this code section, that hopefully should take care of that. So that plus 168, just a typo on undo, and I think is the only thing I can see for now.
all right. Any more questions or comments from the committee before I go to the audience?
Thank you. Now, Mr. Okay. To the author is
sorry, Representative Gravely. Representative Gravely.
Thank you, Mr. Chairman. Has serious question. Has the bar ever disbarred a district attorney in the last 10 years or so for misconduct or
I don't.
We have a former prosecutor on the committee, and Representative Reeves, do you have any knowledge of that?
I can't think of any, but that doesn't mean that that it hasn't happened. But I can't think of
On top
any.
of that, I would say that in my prying and trying to figure this out, I don't know that they've even reprimanded publicly an elected prosecutor, much less disbar one.
Okay.
Thank you, Representative Gravely. Any more questions or comments before I go to the audience? If not, I'm going to go to the audience. I have a Herb Crawford. If you're in the hall, would you please come in and, oh, here you are, Mr. Crawford. Come on. Is it Crawford or Cranford? My apologies. You can try mic 4 right there if you like. I'll take my mask off. Please introduce yourself and let us know your thoughts.
Appreciate it. Yeah, I'm Herb Cranford. I'm the district attorney in the Coweta Judicial Circuit, 5 counties: Coweta, Carroll, Troup, Meriwether, Heard, elected 2018 special election and just reelected in 2020. I'm the treasurer for the District Attorneys Association, and I'm here on their behalf. I really appreciate y'all hearing from me and offering my thoughts. I'm happy to take any questions, obviously, so feel free. I want to start out by saying the District Attorneys Association is not opposed to scrutiny or accountability. I think, other testimony throughout this process has made clear where we stand on it. But that being said, I want to offer some kind of constructive thought and following the amendments, listening outside. I appreciate the fact, one of the comments I was going to make was adding some prosecutor experience as a requirement. I think that's really valuable. Being an elected district attorney or an elected solicitor is really unique within the law, it seems to me. You're representing the state, you're not representing a client. Your interest is in serving justice, and on top of that, you're getting elected, right? So I think it's really valuable. And if this is going to move forward, I think it's really necessary to have some prosecutor experience at both levels, the investigative and the hearing level. I'm not clear on.
Mr. Cranford?
Yes.
I don't want to interrupt. Before you go any further, I want to
Yeah.
address that. So we have required on both panels a prosecutorial experience. In fact, there's a requirement for 3 on the investigative panel. And on the hearing panel, we have a
District attorney who's the
District
chair
attorney.
of that.
Right. And
so we hear you loud and clear there.
Yeah, appreciate that. And is that a currently elected district attorney or a person who's been an elected district attorney? Or I guess, could it be either?
It could be either.
Okay, I appreciate that. I and the association had some concern about the statutory language and in a couple places. I'm not sure, frankly, if y'all address that in the version of I that I have. Subsection 2, subsection A had the language undue bias or prejudice against the accused or in favor of persons with interest adverse to the accused. If that's still in, we just weren't clear what exactly that meant and what it was seeking to address. Because we are advocates, I think for all these rules, but this one as an example, we would just really like to see as much clarity as possible so that, given, that there may be rules in place, we just want to be able to know exactly what they are so we can abide by them. The second,
I'm going to let Representative Mclaren and then Chairman Reeves. We're just going to go one by one on your questions and see if we
Okay.
can address them. Okay. Representative McLaurin.
Thanks, Mr. Chair, and Dear Cranford, good to see you as always.
Yep.
I think what A is trying to get at in terms of the latter part in favor of persons is the idea that we obviously don't want the DA's office or Solicitor General's office to be a platform for harassing the enemies of anybody, right?
Mhm.
And so if somebody were partial to an interest or a person who wanted to see somebody else prosecuted for some reason that was not kosher, then A would capture, and again, that word undue, I agree, is, once we fix it, is going to be carrying a lot in terms of the weight. I mean, even if we were to add undue bias or undue prejudice, put undue twice just to make 100% clear, because I know the concern is that when you prosecute somebody, you could argue that that's inherent bias or inherent prejudice. So I guess my question to you would be, do you have a suggestion for how to tinker with A, if say we were, to allay your concern, given what I think you would agree is a legitimate interest in preventing biased or motivated prosecution for reasons that aren't justified?
Yeah, I think that is tricky. My concern, I guess, would be, and I understand what you're saying. I think that's a almost inherently subjective standard. So, like, for example, in prosecuting people, I've had somebody, claim we were prosecuting them because they were on a motorcycle and I don't like motorcycles, and I don't know. I feel like, and this is off the top of my head, it's almost in the position of trying to prove a negative, you're prosecuting me because I'm from a nice neighborhood or from a bad neighborhood. And, I understand the complaint process would have some standard of proof there. But I guess that's still just kind of inherently concerning. I mean, I see what you're trying to get at, but that seems nebulous to me, you know.
Well, but I mean, you would agree though, that just going to the one end of the hypothetical, that if I'm personally motivated by a personal grievance, and I know I have a friend who's a DA who agrees to prosecute somebody with whom I have a personal grievance, that's obviously totally impermissible.
Yes.
For that
yes,
reason.
Yes. I mean,
right.
If the motive is not pursuing justice, it is not okay.
Okay. So I think I would struggle to come up with language other than undue bias or prejudice. I mean, part of what we're trying to do with as far as I understand it too, is it's almost like a pleading standard, right? That if you're going to bring a complaint based on a charging decision, you need to be able to show that there's some X factor that takes it out of the normal discretion exercised by a DA or Solicitor General, right? So this list at lines 168 to 173 is meant to provide the basis on which you can actually question a charging decision. And I think we want to be able to, we have to have something.
And then it would go to investigative.
And then, right. So this is,
there.
I mean, the line 163 says the commission may not entertain a complaint on the basis of. So this is a screening mechanism prior to the actual investigation. This is saying the investigative panel can't even consider a complaint that doesn't meet these criteria. So I think I know it's a little nebulous, but I guess my question would be, and you know, maybe it's just a comment, that I don't know that we have a better way of allowing, you know, that type of case to proceed to the commission without leaving it, you know, I know undue is doing a lot,
right?
But that it's, you know, at least there's a colorable argument, almost like you state a claim that there was some kind of bias or prejudice or influence that the prosecutor was using that was impermissible.
Right. And I don't know at what point it might be too late, but I'll certainly think about that and carry that back to the association.
Sure.
For any thoughts.
And it's got to be a sworn affidavit. So those are the couple of things that we added is somebody's really got to go out on a limb if they're going to make an allegation, you know, you just prosecuted me because I'm from this neighborhood or whatever. They've really got to have something to tell the commission as to why it should get to the investigative panel.
I know for myself, and I think I can say this on behalf of the association, there is some concern, and I think this has been stated to y'all, that some of this could be abused and be frivolous. And, you know, I personally don't know, you know, if a defendant did this, could they try to get me conflicted off of a case and it be used as a sword?
Mr. Cranford, that is the issue that we have been wrestling with as a committee, and we understand the concern about abuse. We hear you loud and clear on that. I think with the addition of the prosecutorial experience, you're going to have prosecutors overseeing prosecutors to some degree. So they have that unique perspective. And I really feel like that this commission is not going to be it's not going to be a gotcha for prosecutors. It is simply going to attach to the bad actors, if you will. But I know that there's a possibility, and in the business you deal in every day, you see it. There's abuses everywhere, but we've been wrestling with that very issue. So I appreciate you bringing that up again. I'm going to call on Chairman Reeves.
Thank you, Mr. Chair. I just want to clarify. You had asked about in line 78 if the DA appointment would be an elected or a former, and as I read it, I think that it would be a currently elected DA. If you look at line 82, when we're referencing the judge, it says one former judge of Superior Court. So in reading that together, I think the proper reading of it would be a currently elected DA. And frankly, I think I'm more comfortable with that. I think that's that is the right setup for this. But that's how I read it. I don't know if anyone else has a different interpretation, but I think when you read it in light of 82, that's the conclusion that I come to.
I think that's a logical interpretation. I didn't notice that.
I've got an 11 flashing. Who's 11? Representative Smith.
Thank you, Mr. Chairman. I just wanted to thank one of my DAs from the 18th House District for showing up. I appreciate your perspective. Mr. Cranford, what would you suggest we do different on this? What would you see as being something that we could still achieve our aim here of oversight for our DAs in this state?
You're welcome. First of all, good to see you. Again, I'm here speaking on behalf of the association, and we've by vote taken the position we have. I appreciate being given the floor with I guess that broad of a question. I know y'all put a lot of work into this so far. I guess to give a somewhat broad answer back, as much clarity, as possible about what the rules of the road are. So one thing that occurred to me in thinking through this, as I understand, I think there's a distinction maybe between rules and standards. And if I was understanding that correctly, are the standards the things listed in the statute? And then the rules will be created subsequently?
We're giving the commission the levity to be able to promulgate both the rules of the governance of the commission and also the standards by which the DAs will be held to standard of conduct standards.
The version I'd looked at had certain things in the statute, that would be kind of violations. So something that occurred to us was, to what extent could rules be promulgated, given that there are things in the statute? Is that going to be a limiting factor on one side of the coin? The other side,
It's actually meant to be a limiting factor, and so it was goalposts or guidance to the commission. Is this is the direction we like to see you go with the standards of conduct, and so any standards of conduct that will reinforce these statutory requirements is what we're looking for.
Okay, yeah. So I think maybe again, appreciate kind of being given the floor on a broad question. I think if we had our choice, we would like to see it all be rules that could be debated at great length and discussed. And I understand the legislative process is what it is, but I think if I had to answer that one way, it'd be
Mr. Cranford, you and I are of a like mind, my friend. We have two problems with that. We have a time problem, and we also have a separation of powers problem. And to put this standard of conduct within statute, there is a opinion that it would be an overreach by the legislative branch over the judicial branch.
Gotcha. I appreciate that. That did not occur to me. I appreciate that. I think that kind of covers the things I wanted to mention here. Just to reiterate, I and I think we appreciate having prosecutors at each step of this. That was probably number one. And then the second was just as much clarity as possible so that it can't be abused and done frivolously. Again, we're not opposed to scrutiny or accountability. I think, we prefer that be just the bar, but I understand, y'all have your prerogatives and that's appropriate. So
there's a question asked, maybe you can answer, Mr. Cranford. Representative Gravely asked, do you recall any time that the bar has ever disbarred a sitting prosecutor?
I was thinking about that when the representative asked. As you may guess, I'm not the most tenured person around, so perhaps my predecessor, Mr. Scandalakis, could answer that.
I actually have an answer. I think
I do too.
Yeah, so in 2008, DA Tim Madison was disbarred for his felony conviction of theft while DA. And then 2005, Bob Ellis was the DA of Circuit of South Georgia, was disbarred for federal crimes.
Thank you.
2005 and 2008.
Nothing in the 10 years, which was your question, I think. So.
Chairman Reeves.
I want to make one last point. I know you said you appreciate, having district attorneys and solicitor generals involved, and I will say I didn't come up with this idea alone. I did have the help of a number of district attorneys. I don't know many solicitors. We don't have one in my district, but helping come up with the language and of the initial setup. So we have, I have been trying to get them engaged and involved, and it was a handful of them who've helped move the needle on this. So
Appreciate
I hope that, I know that doesn't help the association, but I hope that you guys do feel more comfortable that it's not just the legislature, that's my goal, but they've been a part of the whole process.
Yeah, no, I really do appreciate the involvement of prosecutors. That was the number one thing I wanted to bring up. Yeah.
Well, thank you, Mr. Cranford. I appreciate your testimony. And if you have any other questions or anything, you can catch us in the hall afterwards.
Appreciate it. Thank y'all.
Thank you. Do we have any more discussion out of the committee? Representative Mopdan or Gravely? Excuse me.
Thank you, Mr. Chairman. Given this some thought, I work for a legal association. A lot of times, it is tough. There is, forming an oversight committee like this. I know there's caution and pause when you have attorneys overseeing judges and other panel members with our JQC. When you have doctors that are overseeing doctors for medical review, it can be nerve-wracking. But I think to the DA's point, it is a unique profession. I believe it's a very honorable profession. I mean, DAs are members of public safety, in my opinion. And I think that good DAs across this state are affected negatively when bad actors do the things that they've done in that position. And I feel very strongly that DAs in this state that end up serving on this oversight committee are going to want to do the right thing because they feel very strongly about their chosen profession. They hold the office in high esteem, and it's an honor. And I think that when we see 3 recent instances over the last 2 years, the behavior of certain individuals, I think it puts a scar on the office of DAs across the state. And I know that there are very good DAs across this state that really, I know them. I mean, pack out there in the hallways. Those are good men and women that represent the Prosecuting Attorneys Council. I've known them for many years. I consider them friends. And I think they too want to ensure that position in all of our circuits and counties around the state is held to a high esteem. But it is, anytime you create something like this, there's probably a little bit of how's it going to be executed, what's going to come into play, is political vendettas going to come into play. And I believe that the people that are going to be appointed to this oversight committee are going to be individuals that take it very seriously, and they're going to be individuals that want to see this profession upheld in an honorable way. I appreciate you, Bill, and I appreciate you bringing the bill. Thank you, Mr. Chairman.
Chairman Reeves.
Thank you, Representative Gravely, for that. And I think that I might have said this back in the first hearing on this, but one of the things that I've been pleasantly surprised at, and I've been fortunate that the governor has appointed me on 4 different commissions, and I've had an opportunity to participate in them. And what I have learned is that the people really do take this very seriously when you get appointed by a figurehead to something like this. I just think there's a very natural tendency to realize this is a big deal. I need to take it seriously. And I have found that's been the demeanor of folks on these things. And I think that will absolutely be the case in this. That's all I have to say.
Thank you, Chairman Reeves. Representative Boady.
Thank you, Mr. Chair. And I might be going a little bit in the weeds about this.
You're in the weeds.
I'm just on lines, it's dealing with the selection process for the 3 panel members. And I see in line 76 that that citizen member is going to be appointed by the governor. But I see in line 78 that the district attorney shall be elected by vote of the Senate. And then in 82, line 82, 83 saying that the individual shall be a vote by the House of Representatives. Now, as far as the nomination is concerned, is that going to be done by the Judiciary Committee and the House and the Senate? So they would choose the individual and nominate them for the floor vote? because I think that's important, because right now we don't know how that person is going to be selected. And I typically know from how we do, I guess, selections or appointments by the House and Senate, it normally starts with judiciary. So I don't know if that's something we can look at. Still not in favor of the bill, but just trying to make it, as clear as possible.
Yeah,
Go
so
ahead.
we just specify they'll do it however, the process is that they do. I think the Senate elects some people today. I think the House is too, from an audit standpoint. I'm not sure how that starts off, but I know that it's done elsewhere. And I think that the leaders of whoever they are at the time will make that happen appropriately.
It also says here in line 49, the prosecuting attorney council may recommend to the respective appointing authorities a list of names of individuals for consideration to serve as the attorney commission members.
Yeah, they'll give us names to consider for sure.
Okay,
How
thank
the
you.
actual nomination happens, I don't know.
Okay.
But I would like you to reconsider. I mean, you guys did two Democrats did do two bills very similar to this. You wanted it. You did a press conference on it. I hope that we can get you there. We've worked really hard to incorporate some of the thoughts that you guys have had, and Josh Mclaren's been very helpful in helping us craft this language. And the end result is what you guys have been trying to do, and I hope it just wasn't politically that you guys are trying to do it. That you actually want to make a difference there.
Definitely want to make a difference. Definitely not political. We're just in a different space with the DAs having passed an upgrade and modified rule 3.8.
But they've been working on that for over a year.
Let's let me jump in here, fellas. We've litigated this to death, and I appreciate both of your point of views, and I don't want to cut you off here, but I do want to get moving with this bill. At the appropriate time, I'd entertain a motion.
I move to pass.
We got a move to pass in a second, and we have hearing. This bill has a motion and a second. Is there any further discussion? Are there any amendments? We've got Chairman Reeves.
Thank you, Mr. Chair. I would move that we amend. I would call this the Mclaren/Reeves amendment that Representative Mclaren and I worked out. And it would be inserted in line 174. So for context, this is the section of the bill that deals with the limitations that we're placing, kind of the filter on the complaints. And we would add in line 74, F, capital F in parentheses, and the amendment, and I've given it to Brian in writing, but a stated policy, comma, written or otherwise, comma, which demonstrates that the district attorney or solicitor general categorically refuses to prosecute any offense, comma, or offenses, comma, of which he or she is required by law to prosecute, period. And that would help differentiate between the different, the difference in interpretation of charging. As we all discussed, we wouldn't want a district attorney to face scrutiny of this because they had to make a difficult charging decision on any particular case. However, within that, if there was a prosecutor that decided that they did not feel that it was necessary to prosecute any categorical offense, that would be something that could be subject to this complaint. And if you want me to read it again, I'll be happy to.
Thank you, Chairman. I'm going to go ahead and say, from the members, is there any discussion on the members' amendment? Representative McLaren.
Thanks, Mr. Chair. And the reason I co-signed this is because, and just to be totally clear, if this amendment is not made, then the concern about categorical refusal to prosecute is more profound, right? This amendment alleviates that concern more. I'm okay with it because it uses the word stated, meaning we're not going to second guess somebody unless there's a stated policy, either on TV or in writing or in an internal staff meeting where the directive is given, do not prosecute these offenses. But in any event, it has to be express. And I think that solves the majority of our concerns about, categorical refusal, while prohibiting a fishing expedition just because there's maybe a lack of certain cases that you want to see prosecuted, unless there's that stated policy. So I just want to explain from my perspective why I think there's, meeting in the middle on this.
Thank you, Representative McLaurin. Further discussion, Representative Gravely.
Two questions. Just for my own personal knowledge, is this an amendment the author considers to be friendly? Okay. In that case, the friendly amendment, that is the Reeves Mclaren amendment, is that amendment perfect the bill enough for the representative to consider voting for it?
Yeah, in fact, I was going to support the bill without that amendment, but I'm making
Okay.
it in part because I think it addresses, in good faith, it addresses concerns from the authors and the chair that,
Fantastic.
you know,
Thank you, Representative McLaurin.
Thank you.
Representative Gravely. We have a motion on an amendment we'll call the bipartisan amendment. Do we have a second? We have a second. We have a motion and a second for amendment. All those in favor signify by saying aye. All those opposed? No. It's the opinion of the chair that that amendment passes. Any further amendments? I'm going to offer one amendment. On line 68, there's a typographical error. 168, excuse me, 168. Instead of undo, it should be undo. UNDUE, not undo. I'm going to call that the Burchett Amendment. Do I have a second?
Second.
We have an amendment and a second. Motion and a second, excuse me. All those in favor signify by saying aye. All those opposed? Thank you. Are there any more amendments? Hearing no more amendments.
He did, yeah. That one piece that they skipped.
Okay, I just want to make
No, the one that they missed, the legislative council.
That's right. Yeah, thanks for reminding.
Part of I think is what.
Representative McLaurin.
yes, thank you, Mr. Chair, and thanks for the reminder, Brian. Line 162, the amendment would be, nothing in this code section shall be construed to limit the ability of the commission to bring a complaint pursuant to this code section on its own motion. Can I say it one more time? Okay. Nothing in this code section shall be construed to limit the ability of the commission to bring a complaint pursuant to this code section on its own motion.
We have a motion to amend. Do we have a second?
I'll second it.
We have a second. All those in favor signify by saying aye.
Aye.
All those opposed?
No.
Is the opinion of the chair the amendment passes. Any more amendments or discussion?
Thank you, Mr. Chairman. Representative Gillett, I know you and I talked early on, and I appreciate your diligent work. This would in no wise affect the legislature's ability to impeach a district attorney still, would it?
That's correct. It does not.
Okay, good.
Thank you for that question. Okay, hold one. We have a motion and a second on the passage of House Bill 411 LC 413072S as amended. All those in favor of passage, please signify by saying aye. Aye. All those opposed?
Aye.
Thank you. Is the opinion of the chair that the measure passes on the rules? I appreciate everybody's work bipartisan wise. I appreciate Gullett's just tenacity getting this thing as far as it's been so far. I wish you the best of luck in rules.
Thank you.
Representative Bradley.
Mr. Chairman, I just want to say that Joseph's Representative Gullett looks a lot better at the end of this committee than he did at the beginning of the committee.
It's the pearl cream, I guess.
We got one more measure to consider, committee. I appreciate your hanging tight with us. We're getting close to the end here. And with that, I'm going to ask Representative Neal to present her bill. It's House Bill 236 LC 480409S. As she's making her way to the microphone, this is a bill that Representative Neal brought and has worked extensively with law enforcement. And the gist of the bill is essentially that when a temporary protective order is issued, a list is given to the local police or law enforcement, excuse me, including police departments and sheriffs, to allow for security checks to be ran in their normal course of patrolling at the discretion of the law enforcement officers. So I just wanted to eat up some time, Representative Neal, while you were coming up. I didn't mean to steal any thunder by any means. I'm going to turn this over to you, and I know you've been working hard on this measure, so I appreciate you bringing it.
Thank you so much. Thank you to the chairman, Chairman Burchett, and Subcommittee Chair Reeves, the committee members for their input as well. Almost every person here has contributed something to this bill, and I definitely appreciate it. To include the Georgia Chiefs of Police, the Georgia Sheriff's Association, the Georgia Peace Officer Standards and Training Council. This has been a collaborative effort, and I appreciate everyone. I appreciate the committee for allowing us to keep coming back to get it right. I bring to you House Bill 236. So as one person on this committee said yesterday, restraining orders are known to be not to be worth the paper they're written on. And this bill aims to change that. Citizens want a little bit of extra help, and this is that help. This bill allows for petitioners to request safety checks by their local law enforcement agencies after they have filed a restraining order when they feel that their safety is still in jeopardy upon filing the order. And that's the gist of it. I know we've been through a number of versions of this.
This has, like many bills that come through Judiciary Non Civil, this has met many iterations, and
yes.
We definitely scrutinize these bills. So with that said, I don't think we do have some folks. Are these folks signed up to just as needed?
Yeah, they just
okay,
want to
so
be available to the committee.
If there's any need for them, we'll call them in. I'm going to ask that I'm going to open it up to discussion by the committee. So if you have any questions from the committee to the author, here you go. Representative Boady.
Thank you so much, and to Madam. Thank you for your hard work. I know you've went through a lot of different versions of the bill, but I guess I want to make sure that your version, new version, makes it more, elective or, more selective for law enforcement. Doesn't require anything, because I noticed where I think on line 17, the shall was changed to a may. And I know that was very important for some of the members of this committee. So this is more of an elective type of law enforcement. They can, they will, but they won't be forced to, right? Thank you.
Absolutely. That's exactly the purpose of that change and
Okay.
the other changes that were provided since yesterday.
Thank you so much.
Thank you, Representative Boady and Representative Neal. Any other questions or discussion of the author, or any other questions in general? The time would be appropriate to make a motion. We have a motion. Do we have a second? Any discussion? Any amendments? Hearing none, I'm going to call the question for House Bill 236 LC 480409S. All those in favor of this measure, please signify by saying aye.
Aye.
All those opposed, same sign. The measure passes. Congratulations, Representative Neal.
Thank you, sir.
You can find a rule sheet in my office and go ahead and fill it out. You want to get it signed. If you can, get it signed tonight before I leave, and then you'll be ready for rules. With that, we're going to adjourn. Thank you again for staying late, all of you.